In many parts of the world, marriage is a choice, a conscious decision marked by a ceremony, a certificate, and a public vow. But in Canada, you can be married in the eyes of the law without ever saying, "I do." You can enter into a binding legal relationship simply by sharing a home, a bank account, or a life. This is the world of common law, a legal framework designed to provide fairness, but one that often becomes a financial minefield for the unprepared. Most couples believe that as long as they haven't signed a marriage license, their assets are their own and their future is private. They're wrong. In this country, the clock starts ticking the moment you move in together, and by the time you realize you've signed an invisible contract, it might be too late. Today, we are pulling back the curtain on the silent rules of cohabitation. We are uncovering the three massive myths that have cost unsuspecting Canadians and newcomers thousands of dollars and years of legal heartache.
This is the unseen contract, and the truth about your relationship might be the most important business decision you ever make. The first myth that destroys financial futures is the 6-month mirage. Many beginners believe that you only become in common law after a very long time, or perhaps after just 6 months of living together. In reality, Canada has a fractured legal landscape where the definition of time changes depending on who is asking. Under the Income Tax Act, the federal government considers you common law after just 12 continuous months of cohabitation. However, if you are looking at provincial laws for property division or spousal support, the requirement might be 3 years, or even 0 years if you have a child together. Consider the story of a young professional in Ontario who moved in with his partner. He thought he had years to figure out their financial arrangement, but after just 1 year, the Canada Revenue Agency legally reclassified them.
By failing to update his status, he unknowingly committed tax misrepresentation, leading to thousands of dollars in clawed-back benefits and interest penalties. The secret here is that in Canada, the law doesn't wait for you to feel ready. It has its own calendar, and if you don't watch the clock, the state will do it for you. Perhaps the most dangerous misconception is the belief that common law is exactly the same as legal marriage when it comes to property. In a legal marriage, the matrimonial home is often split 50-50 regardless of whose name is on the deed. But in a common law relationship in provinces like Ontario, there is no automatic right to divide property. Imagine a woman who spent 10 years contributing to the mortgage of a home held only in her partner's name. She paid for the renovations, the groceries, and the bills, believing they were equal partners. When the relationship ended, she discovered that under the law, she had no automatic claim to the house. She had to fight a multi-year legal battle using a complex concept called unjust enrichment to prove her contribution. The legal secret that beginners miss is that in Canada, common law status gives you many responsibilities, but it does not always give you the same rights as a spouse. If your name isn't on the paper, the law doesn't assume you own the bricks. The third myth is that if you aren't married, you don't owe your partner anything when the relationship ends. This is the support trap. Under the Family Law Act, common law partners can be legally obligated to pay spousal support, sometimes for the rest of their lives. Take the real-life example of a business owner who lived with a partner for 5 years. When they separated, a court ruled that because the partner had sacrificed their career to support the household, the business owner had to pay monthly support payments that totaled over $80,000 over several years. The law looks at the interdependence of your lives, not the presence of a wedding ring. The secret to surviving a common law relationship in Canada is the cohabitation agreement. Without this legal shield, you are leaving your financial destiny in the hands of a judge who only sees the numbers, not the emotions. In the eyes of Immigration, Refugees and Citizenship Canada, or IRCC, a common law relationship is a gateway to a new life, but it is also a gateway that is heavily guarded. To sponsor a common law partner, the law requires absolute proof that you have lived together in a marriage-like relationship for at least 1 continuous year. This isn't just about sharing an address, it's about proving a shared life. The danger for beginners is the marriage of convenience investigation. Under Section 4 of the Immigration and Refugee Protection Regulations, if an officer believes the relationship was entered into primarily for the purpose of acquiring status, the application is refused and a 5-year ban for misrepresentation can be issued. The secret that newcomers often miss is that the IRCC looks for interdependency. They check for joint bank accounts, shared utility bills, and even social media history. If your digital life shows you living separate lives while your paperwork says you are a couple, the law will treat it as a fraud. In Canada, immigration isn't just about love, it's about the legal evidence of that love. While you might think your relationship status is a private matter, the Canada Revenue Agency disagrees. Every year, thousands of Canadians are audited for their marital status. Why? Because your status determines your eligibility for the GST/HST credit, the Canada Child Benefit, and other tax-free payments. If you claim to be single to get higher benefits while living in a common law relationship, the law views it as tax evasion. The secret is that the CRA uses sophisticated data matching. They track address changes, shared credit applications, and even employment records. If you and your partner have the same address on your T4 slips but file as single, a red flag is raised. Once the CRA determines you are common law, they can claw back years of overpaid benefits, often totaling tens of thousands of dollars. In Canada, your relationship isn't official when you feel it is. It's official when the government's data says it is. One of the most brutal realities of Canadian common law status occurs when a partner passes away without a will. This is known as dying interstate. In many provinces, including Ontario, common law partners have no automatic right to inherit their partner's estate if there is no will. While a legal spouse is protected by provincial succession laws, a common law partner can be left with nothing, even if they live together for 40 years. Imagine a situation where the family home is in only one partner's name. If that partner dies, the house could legally go to their estranged children or parents, leaving the surviving common law partner homeless. The only secret to surviving this legal nightmare is a properly drafted last will and testament. Without it, you are a legal stranger to your partner's legacy. In Canada, the law does not assume your partner wanted you to have their assets. You must prove it in writing before it's too late. There is a common myth that common law parents have fewer rights or responsibilities toward their children than married parents. This is entirely false. Under both the Federal Divorce Act and provincial legislation like the Children's Law Reform Act, the law treats parents as a single category, whether you were married for 20 years or had a child after a single month of cohabitation. The best interests of the child is the only standard that matters. Child support is not a choice, it is a legal right of the child. The secret here is that child support is calculated using the federal child support guidelines, which are strictly based on the payer's income. You cannot contract out of child support in a cohabitation agreement. In the eyes of the Canadian court, your relationship with your partner can end, but your financial and legal obligation to your child is a lifetime commitment. For the entrepreneur, a common law breakup can be a threat to the business itself. If you own a company, your partner may be able to claim a portion of its value through a constructive trust. If they can prove they contributed to the business, even indirectly by managing the household or providing unpaid labor, a judge may rule that they have an equitable interest in your shares. The secret is that the law looks for a link between the partner's contribution and the enrichment of the business owner. If you built your business while your common law partner paid the rent and raised the kids, the law may decide that they help fund your success. Without a clear legal agreement, your business partners aren't just the ones on your board of directors. Your partner at home might legally be one too. Canada is a confederation, and when it comes to common law, your rights depend entirely on which side of a provincial border you stand. In British Columbia, common law couples are treated almost exactly like married couples regarding property after 2 years. In Ontario, you can live together forever and never have a right to your partner's property. But the most unique case is Quebec. Under the Civil Code of Quebec, de facto unions or common law relationships provide almost no automatic protections. There is no spousal support and no automatic division of assets. The secret of provincial warfare is that your legal safety net changes the moment you move provinces. If you are moving from Vancouver to Montreal, you are moving into a completely different legal reality. In Canada, geography is destiny when it comes to your relationship rights. If you take only one lesson from this 250-minute journey, let it be this: you must draft your own rules. A cohabitation agreement is your legal shield. It allows you to decide on your own terms how property will be divided, whether spousal support will be paid, and how debts will be handled if the relationship ends. To be legally binding in Canada, this agreement must be in writing, signed by both parties, and witnessed. Most importantly, each partner should have independent legal advice. If you don't have your own lawyer review it, a judge can throw the whole agreement out. The secret is that a cohabitation agreement isn't a sign of a lack of trust. It is a sign of a high-functioning professional partnership. It is the only way to opt out of the government's default rules and protect your future on your own terms. We have explored the 250-minute landscape of the unseen contract. We have seen how love, when combined with the law, creates a complex web of rights and responsibilities. Canada is a land that values fairness and protection, but it is a land that expects you to be an active participant in your own legal life. Do not look at these rules with fear. Look at them with the eyes of a master. Knowledge is the key to a life of freedom and security. By understanding common law, you are not just protecting your bank account, you are protecting your peace of mind and the legacy you are building in this great country. Speak the truth to your partner, put your plans in writing, and walk into your future with the confidence of someone who knows exactly where they stand. You are the author of your own story. Stay informed, stay protected, and welcome to the future of Legal Secret.